And then we also have Senator Whitehouse, but I want to go and let him comment. So,
Senator Grassley, may I be recognized after Senator Whitehouse?
yes.
Mr. Chairman, thank you. I was disappointed to see last night that some of our colleagues are unwilling or unable to conduct themselves in this hearing with regular order and in accordance with the rules of the committee and the rules of the Senate. I know last night some of our colleagues even tried to cross-examine the nominee about documents but refused to let him even read them. Members of the Senate and members of Congress generally are privy to sensitive information, including classified information on occasion, and we're expected to protect that information for all of the obvious reasons. And it's inappropriate to raise these in an open session before the committee. And I think our colleagues understand that, but nevertheless decided to go ahead anyway. So I just think it's important that we remind one another that there are clear rules about the discussion of confidential material and that there can be consequences to the violations of those rules. And this idea that somehow President Bush, when his lawyer and the president decide that information represents legal advice or other protected information that was given to the president during the time he was president of the United States, and that somehow he is unable to make a claim of privilege, or that once the claim is made in consultation with his private lawyer that would be not respected by the Senate, is outrageous. And so I thought we were doing pretty well yesterday, but things went off the rails, it looks like, last night. And I hope we will return to a hearing process that respects the rules of the Senate and that treats each other, and particularly the nominee, with the civility that he and this process is entitled to. And I'd encourage our colleagues to avoid the temptation to either violate the Senate rules or to treat the witness unfairly by cross-examining him about a document and refusing to show it to him, and violating the confidentiality of some of these documents as requested by President Bush in consultation with his private lawyer.
Sir, may I respond, because it was directly invoking. May I respond, sir? No Senate rule accounts for Bill Burke's partisan review of the documents. No Senate rule and no history of the Senate accounts for what is going on right now. There was that was following this archives, this partisan operative, following his involvement in this process that I think, in my opinion, undermined the process. And the idea that we could somehow go through your lengthy process when many of these documents are dumped us in the last minute. But to Senator Cornyn actually made a very good point. I knowingly violated the rules that were put forth, and I'm told that the committee confidential rules have knowing consequences. And so, sir, I come from a long line, as all of us do as Americans, and understand what that kind of civil disobedience is, and I understand the consequences. So I am right now, before your process is finished, I'm going to release the email about racial profiling. And I understand that the penalty comes with potential ousting from the Senate. And if Senator Cornyn believes that I violated Senate rules, I openly invite and accept the consequences of my team releasing that email right now. And I'm releasing it to expose that, number one, the emails that are being withheld from the public have nothing to do with national security, nothing to jeopardize the sanctity of those ideals that I hold dear. Instead, what I'm releasing this document right now to show, sir, is that we have a process here for a person, the highest office in the land, for a lifetime appointment. We're rushing through this before me and my colleagues can even read and digest the information.
Can I ask you how long you're going to say the same thing 3 or 4 times?
No, sir.
How long do you want?
I'm saying I'm knowingly violating the rules.
Okay.
Senator Cornyn called me out for it.
How many times you going to tell us,
sir? I'm saying right now that I'm releasing committee confidential documents.
Mr. Chairman, since the senator invoked my name, I do
and I
insist on an opportunity to respond.
Now-
I did not mention his name,
okay.
but he had mentioned my name, and he's right. Running for president is no excuse for violating the rules of the Senate or of the confidentiality of the documents that we are privy to. This is no different from the senator deciding to release classified information that is deemed classified by the executive branch because you happen to disagree with the classification decision. That is irresponsible and outrageous. And I hope that the senator will reconsider his decision, because no senator deserves to sit on this committee or serve in the Senate, in my view, if they decide to be a law unto themselves and willingly flout the rules of the Senate and the determination of confidentiality and classification. That is irresponsible and conduct unbecoming a senator.
Since,
Chairman.
well, just a minute. The chair's
Chairman.
got something I want to say. I think we ought to be thinking about, this is the last, I got 3 senators are asking for it. Senator Kennedy, Senator Whitehouse, and Senator
And Mr.
from
Chairman,
Connecticut. So
I would like
so
to also be
so this is the last day. So here's something you got to think. We'll be here till midnight if you want to be here. But I've been told that the Senate minority leader or somebody in the Democrat parties invoked the 2-hour rule. So if the 2-hour rule is invoked, that's nobody on this committee, Republicans or Democrats, going to have an opportunity to do what they want to do today, because this is the last day he's going to be here, and so I hope you don't invoke the 2-hour rule. So if you want to talk now before I start to ask my questions, I'll do it. Senator Whitehouse was the next one, and then Senator Kennedy.
Thank you,
Mr. Chairman, I'd also like to be recognized because I am in a similar situation as
Senator
my colleague
Whitehouse.
here.
I think he asked before you did.
Mr. Chairman, you recognized me for 30 seconds, and I will take 30 seconds. Lest silence imply consent, speaking for myself, I want to make it absolutely clear that I do not accept the process of this committee confidential routine that we went through. I do not accept its legitimacy. I do not accept its validity. Because I don't accept its legitimacy or validity, I don't accept that I'm under any obligation. I have not made a big fight about this. I've just gone ahead with my questioning. But again, lest silence imply consent, I think that rule is as ineffectual as if the chair had unilaterally repealed the law of gravity. It simply isn't so. I haven't agreed to this rule. I haven't voted on this rule. This rule does not exist in our committee or Senate rules. And I'll leave it at that. Just me speaking. I am not willing to concede that there is any legitimacy to this entire committee confidential process in this hearing.
Was it just
nothing sensitive, nothing personal, nothing classified, and nothing confidential has been released?
Did you object to it when it was previously used under other Supreme Court nominees?
It was developed then through a bipartisan process in which we had reached an agreement by unanimous consent, effectively.
No, there was
not by
agreement
decree.
between the chairman
Yes,
and the
precisely. And that did not exist this time. And now you have documents that are not personal, not classified, not confidential, not sensitive, that are nevertheless covered under this.
Senator Kennedy.
Mr. Chairman, I was in the chair last night when this issue came up. I made the call, and I wanted to explain why I made it. Senator Tillis, my colleague, raised the point. I allowed Senator Booker to continue. Sometimes patience ceases to be a virtue, but I didn't think in these hearings, following the chairman's example, that was appropriate. Senator Booker examined Judge Kavanaugh about the racial disparities in this country. I gave Judge Kavanaugh, I think it was 6 minutes and 39 seconds to respond uninterrupted. So I was trying to be, and will continue that, was trying to be fair to both sides following the example of our chairman.
Thank you, Mr. Chairman. There's been a lot of commentary over the last couple of days about how we are in uncharted and unprecedented territory here, that the process has broken down, reflecting what is happening in our nation generally, and particularly in the last couple of days with the publication of a new book and an op-ed that indicate very serious chaos and breakdown in other parts of government. And I'm hoping that we can come together as a committee, and if there are any rules, do what we've done in the past, which is adopt them on a bipartisan basis. That's been the way that committee confidential designation, it's not classification. There's no classified documents here. It's a designation. It's an arbitrary and seemingly capricious designation designed to spare people embarrassment, possibly. But all these documents belong to the people of the United States. They're covered by the Presidential Records Act, and eventually they will come out. So shame on my colleagues if they conceal them now and deny us the benefit of questioning this nominee who comes before us for the last time today. He comes before us for the last time today. This is our last opportunity, up or down, whether he's confirmed or not, to question him. And like any trial lawyer, documents have to be assessed as the trial goes on, as this witness responds to our question. We can't give the chairman a list of what documents are relevant before we hear his answers and our colleagues' questions. So not only from the standpoint of there being no basis for the rules, but also to deny the fairness and effectiveness of the process. That's the reason that we're making this protest, and we are here under protest. That's the reason why I asked to adjourn, so that we could consider fairly all of these documents. I appreciate that Senator Grassley has decided to release the documents that I would have used yesterday. He's released the documents that Senator Booker commendably would have released, even if not reclassified or redesignated. But I want to reserve the right, I hereby reserve the right to release documents before any confirmation vote, so that my colleagues can see what the truth is. We are literally trying to get at the truth here. And between now and any vote on confirmation, there is the right, in my view, on the part of every member of this committee to release documents that she or he believes are appropriate, and to delegate this decision to an unappointed and unconfirmed and largely unknown figure, Bill Burke, who used to work for the nominee, is the height of irresponsibility. Thank you.
I want to start by pointing out that when this part of the discussion started last night, I was concerned that, as with any witness in any courtroom or any proceeding before this committee, I want to make sure that when a witness is questioned about a particular document, the witness has access to that document. It's not fair to the witness who has, over the course of his career, been involved in the creation, the authorship, the review of not just hundreds of thousands, but many millions of documents in his lifetime. It's not fair to this witness or any other witness in any other proceeding anywhere to not give the witness a copy and allow him to respond to it while he's being questioned about it. So that's why I offered to Senator Booker, and Senator Booker and I had a helpful conversation with the very helpful committee staff last night, and they've agreed in the meantime to release this same document that was now the subject of it. So the process worked. It works. We do have the ability to make these things available, to make them public, so that we can be fair to Senator Booker, we can be fair to the witness, to the nominee. I do want to point out, since the charge has been made that this process is somehow rigged, that it's charged, that it's unfair, that it's arbitrary, that it's capricious, I completely disagree. We are not dealing in a lawless environment here. We're dealing here with the Presidential Records Act. We've got documents that are the subject of privileges, privileges that have to be asserted. Now, Bill Burke is the designee for that presidential administration. and has the prerogative of asserting privileges.